Sexual harassment's another area where the maritime law is very much out of sync with shoreside law. In substance, it is that a seaman cannot claim damages for sexual harassment unless there's an accompanying physical injury, or if the harassment occurred in the circumstance of an immediate threat of imminent harm. And so, in other words, if you are being attacked physically and avoid the attack, that might satisfy it. So we had the case of a cook, female cook on a container ship, and she had gotten involved in an affair with a fellow who was a captain for this company, and the two of them had made a bad decision to take a ship together, and they didn't normally work together, but captain invited her and she decided to do it. So they did. That's a lousy idea and doesn't usually work out well. And it didn't in their case, because after they started the cruise, their relationship fell apart. Cook broke it off and the captain wasn't ready to break it off. And so he started pursuing her on the ship, and it got really weird. And eventually he was doing things that were so frightening to this gal that at night was barricading herself in a room, putting her furniture behind the door, so because the captain had the key and she wanted to be sure and keep him out. And the circumstances of the harassment were pretty dramatic, but there wasn't any evidence that there had been any physical injury associated with his behavior, and there wasn't any overt threat of physical harm. And so we took that case to trial, and the court eventually tossed it out on the basis that just sexual harassment alone isn't enough. And we took that case all the way to the Ninth Circuit Court of Appeal. And well, I really expected that, the Ninth Circuit being at least accused of being a great bastion of liberal thought, that they would take a look at this law that applied to seamen, where it says that you cannot sue for sexual harassment unless there is an accompanying physical injury, that they'd take a look at that and toss it out. But they didn't. They took a look at it and said, you should have read the Gottschall case. That's the case that established this. Says, go read the Gottschall, dummy. That's about what the Ninth Circuit thought about it. But I certainly don't have any regrets about taking that case to trial, because other lawyers know about it. Someday somebody's going to get a court of appeal somewhere to say, wow, that's wrong.